So I was told after my Ignite presentation on Thursday that I lack passion. Seriously. I teach at the University of Pittsburgh. My primary area of teaching is in intellectual property law. I primarily teach copyright law and trademark law in the upper level. And I practiced law for about 10 years before I came to teaching. And after a couple of years, I figured out that the standard pedagogy, the standard assessment methods that are expected of you as a junior faculty member simply do not do a very good job. You're not putting your skills to use as a professional. You can't really tell whether you are actually measuring your students' learning. This is no news to any of you here. I was simply figuring this out myself. I felt very alone in all of this. This was 2001, 2002. So a lot of what I'm going to talk about is simply my own journey over the last dozen years. The material that I'll talk through largely is reflective of my ETL portfolio on the ETL website. All of my teaching materials, syllabi, slides, rubrics, student assignments, instructions to students, it's all on my website. It's very easy to find. I'm happy to share it with any of you. Basically, what I did starting in 2002 in my upper level courses is I stopped giving final exams, and instead decided to assess my upper level students through a series of sort of elaborate graded writing assignments, sort of legal memos, but non-standard, non-law school standard legal memos that looked and felt to me as a teacher and were intended to look and feel to students like they were embedded in the actual practice of law, that you're actually working on client problems and expected to analyze and assess them as you would be expected to as a junior lawyer in the practice of law. So the idea of a client sensibility, accountability to clients, service to clients, solving clients' problems, helping direct clients' outcomes was very much a priority for me. And secondarily, I wanted to do something with my students that helped them learn the material more effectively, rather than simply processing it cognitively, actually practicing with it, and primarily through the exercise of writing about it was the challenge. Giving them more writing practice, of course, was a third objective, because we all know that students don't get enough practice in critical writing over the course of their 3 years. So what I'm describing is largely the same technique that I developed on my own 12 years ago. As I've evolved it a bit, partly evolving it because I started over time to learn more about teaching theory, assessment theory. 4 years ago, I discovered this community at ETL, and there's a whole population of people who think like I do, which is wonderful, and I've been sort of backfilling the gaps in my own education and making it a bit more rigorous as I go along, which has been terrific. I use traditional teaching materials by and large, although I'm going to start to make some changes there, change the assessment method, getting rid of final exams, and then, as I said, give students 3 graded writing assignments over the course of the semester. I hand out a hypothetical about 2 weeks before the paper is due. We spend a day in class talking through questions and problems associated with that hypothetical. Sometimes that Q&A is me in role, sometimes it's me as a teacher. Students have a very, very constrained format that they're expected to use. The problems are very open-ended and complex. You have a client, the client has a problem, the client has an intended outcome, go, is sort of the default framework. These are not well structured. These are not sort of focused issue spotter kinds of things. I expect that they will work through 8 to 10 pages of a draft, and then I will give them the restriction that they have to turn in a paper that's only 4 pages long. They can use any materials that they wish. These are completely and purely open assignments. They can consult with each other if they choose to. I don't give them a lot of guidance about how to figure out the best ways for them to work out these assignments. And then I give them feedback that is dripping with commentary. And I say to them at the front of the semester, I will be direct and honest with you in my feedback, as I would if I were a practicing, supervising lawyer. If I like your work, I'll say it's terrific. If I don't like your work, I'll say it's not so terrific or bad. I'll give you instructions and guidance on how to improve it. You'll see on my website, I now have a 10-page single-spaced memo that I make available to them at the beginning of the semester that tells them all about my expectations and how to succeed. I have built out a rubric over time that I share with them at the outset. And then I've learned to do stuff in class that helps them sort of situate cognitively what I'm expecting them to do on the assignment. So here's just a quick illustration of the type of thing that I will do occasionally, not every single class session. This is from my trademark law class. This is, as you know, the University of Wisconsin, the Badgers in the late 1990s. They spent millions of dollars to develop what they call in Madison the Motion W. University of Wisconsin is a very litigious and proprietary university. They sue a lot of people for a lot of things. So I start by explaining to my students that one of the first things that they did is they went after the Washburn University Ichabods. Not exactly a rival on the football field, but you see the University of Wisconsin in the middle there. You see the older University of Washburn University helmet in blue below, the upper one above, and then this is what the Washburn University helmet and logo looks like now after a cease and desist and some negotiation. So that's the background that I share with my students. Then I show them this, right? So this is a real life-based thing. You all know probably that high school football teams and high schools around America love to copy logos of Division I and NFL teams. So we have two high schools, Wisconsin Lutheran, which is a large private football playing school in Wisconsin, and West Lakota West High School in Ohio, which is a large football playing school, public, but not in Wisconsin. So I would then assign about a dozen students to roles. My enrollment in these classes usually is about 40 to 45 students. I learned early on that I needed to cap enrollment. I had a couple of early sections where I had 70 or 80 students sign up for this. So I had to cap it at 50. So I have about 45 students in class. So for the University of Wisconsin, I would say, you're the general counsel, Melissa, right? So then we have the provost, we have the athletic director, and we have the football coach. Okay? So now we've got a team of 4, and you should start thinking about not only the IP-ish dimensions to this, but there's a whole interesting array of ethical questions that surround the composition of that team. Now, over at Wisconsin Lutheran, we have the head of school, we have the school board, chair or president. We have outside counsel, in all probability, probably associated with the local church. And we have the football coach, who has a say and a stake in how this all plays out. And of course, we have the same team of 4, although slightly different names: football coach, athletic director, principal, school board president, outside counsel at West Lakota West. So now I've got about 12 to 13 students in role, thinking a little bit about what they're expected to do and say. And I say, well, go. Right, so we start with the University of Wisconsin General Counsel. So presumably, given this record with Washburn University, you have something that you want to say in writing, presumably, to these other 2 schools. So we do this orally, we do this in class, we do it in full view of the other parties, so there's a certain degree of unreality associated with the disclosure of it all. But we do get some very lively and very unpredicted conversations about what's the tone and tenor of the demand, what's the tone and tenor of the response, what kind of consultations go on within the respective communities, taking into account IP topics, ethical questions, public or private accountability issues, the question of the status of your high school football playing seniors who might want to go play for the University of Wisconsin, or Wisconsin wanting to recruit within state or out of state. Do they care in different respects? Every year this has different outcomes. Sometimes IP issues are salient and dominant. Sometimes ethical issues are salient or dominant. I've had a student working for the University of Wisconsin who quit his hypothetical job over the suggestion that being an aggressive enforcer of IP rights in either of these situations might be the client appropriate thing to do, because it was clearly within the bounds of an acceptable position to take. Student just didn't want to do it, even though the client was basically saying, this is what you would. And student said, I'll quit my job. That's a very interesting moment, right, as a teacher, to have that kind of thing emerge in the conversation. So it's just an example of the kind of thing. I've learned that I need to do stuff in the classroom, right, to prepare the students for the kinds of expectations that I'm putting on them in terms of the assessment exercises. Right, so how do I think about this now 12 years on? I'm still doing this. I've learned a lot. I've refined it. So the practice of doing the work actually does have value. Right, that was my initial instinct, and I've really confirmed that over and over again. The students clearly do grumble and gripe about the amount of work. It's somewhat unexpected that they have to put into all of this, but they clearly do get value out of it. I learned about halfway through developing this technique about writing to learn and writing in the discipline's literatures that was very, very supportive of my initial instinct. There's some obvious drawbacks that will have occurred to you already. Number one, I don't have the time in class class to cover as much of the doctrinal material as I otherwise would. That's an obvious cost. I'm willing to make that trade-off too. It's about double the amount of time that I spend in the assessment of students, right? Compared to the amount of time that I used to spend grading final exams, the time that I now spend marking papers, it's about twice that time. And of course, it's distributed across the entire semester. It's not concentrated at the very end. Third, I've learned a lot about the students, the lack of students' preparation for this kind of exercise coming to law school. They are not well prepared in terms of their writing experiences or their analytical experiences before they come to law school. They're not well prepared based on their 1L legal writing and analysis or other first-year curricular experiences for this type of thing. So I tell them, first day of class, the writing I will have you do looks format-wise very much like the writing that you did in your legal writing and analysis course. These are legal research memos, facts, question or issue, statement of a brief answer, and then analysis. So the template is the same, but the style and the character of the expectations, the kind of payoff is very different. These are not issue spotting kinds of things. I'm not expecting you to execute a formula that you were taught in your 1L year. I'm expecting you to think for yourself, exercise your own judgment, answer the question, because that's really what clients want from you, and their students are very nervous about doing that. Is there evidence that it works? Is this actually having the kind of impact that I want the exercises to have? The jury, I don't have any documented formal data collection. This is still all going on instinct and intuition as reinforced by feedback from this community. I've had a number of colleagues at other law schools take up this method in their IP classes, so there's a little bit of anecdotal feedback on that basis. I have students come back for more. So one source of evidence is I have students who sign up for one of my classes thinking that they'll be intrigued by it, and then will come back and they will take the other one. They'll start with the copyright class, and then they'll come back and take the trademark class, or vice versa, and I will know, because I know the student, that this person is not particularly interested in intellectual property law. So I say, well, why did you come back? You don't particularly like the subject. She says, well, it turned out that this stuff was so useful in my summer job that I knew that I needed to do more of it. And I've had several conversations like that. I've also had a number of students who graduated from law school call me or email me from the professional world saying, aha, they are now doing in the professional world exactly the kinds of things that I was asking them to do as a student. So it's sort of a post hoc rationalization or justification for those students. So it is anecdotal. It's not well-structured, formal feedback that confirms what I'm doing, but it does reinforce that I'm on the right track. I would also say that my colleagues at Pitt have not been particularly impressed by this. I do not have a batch of colleagues. It is not a culture of innovation. It is not a culture of experimentation. I was very lucky. My dean at the time that I did this, when I was doing it initially as an untenured faculty member, my dean was David Herring, my colleague from Pitt, who's now the dean at New Mexico, and so he was very supportive of all this. He knew what I was doing. But the rest of my colleagues, this is very fine what you're doing, but that's fine for you. It's sort of been the attitude. What have I changed? What have I not changed? Sort of last comments here. So things have changed. So the assessment techniques that I devised are more transparent and more explicit. So I now have a rubric. It's a primitive rubric, but it is a rubric. Part of that was in response to student requests, that I be more structured in terms of how I was evaluating the papers. I have learned, not surprising to this crowd, that it helps me be a better assessor. It helps me be more consistent. It helps me be more transparent. It helps me defend my judgments when students occasionally ask questions about the basis for my evaluation. As you heard on Thursday, I now direct this Innovation Practice Institute at Pitt, so I've tried to be more explicit about aligning what I'm trying to do in my course over here with what I'm doing in my community-based engagement and student development over there. So as you inferred from my presentation on Thursday, I have a somewhat different sort of vision of the role of lawyers in society than the classic lawyers as problem solvers model. So I'm trying to align what I'm doing in my classroom teaching with my sort of vision of professional impact when students graduate. So my courses are now not formally part of this IPI, but they are definitely, I communicate the idea that it's the same person engaged in both activities, so there's a consistency in terms of the vision that I'm trying to transmit. What hasn't changed, I still have kind of a law and order kind of technique for finding problems in assignments. I will wait to the last minute, find things that are going on in the world of intellectual property law, new cases, new disputes, things in the news, and I can transfer them into sort of ill-structured assignments sort of on the fly as I need to. I'm very committed to not giving well-structured, non-issue spotting style assignments because, frankly, clients don't walk in your door with issue spotting questions. Clients walk in your door saying, here's my messy problem, what do I do? And worst case scenario, the partner or your supervisor in a law firm walks in your door on a Friday afternoon and says, here's a weird thing that the client just called me about. I'm leaving, have the answer on my desk Monday morning. I'm not quite that aggressive because I give my students much more time to work things through, but I definitely want to kind of leave them hanging at the front end and have them work through the problems on their own. I do not grade the students anonymously, so that's something that my law school has been willing to support me on. I say in the real world of the practice of law, your name is on your work, you're accountable for what you do, so I'm going to treat you like a young professional, and that includes you're having faith that I will treat you fairly and I will engage with you. I'm the senior lawyer, you're the junior lawyer, or I'm a client, you're the lawyer. And I learned a lot this weekend, actually. So I didn't change the slides that I submitted previously in response to things I heard over the last couple of days, but I took a lot of notes over the last couple of days about how to refine some of what I'm doing in the assessing in particular and rubrics and transparency and how to sort of shape students' expectations. So this will continue to evolve. I am likely to build in more team-based work. I have adopted Jillian Hatfield's techniques for contracts. If you know Jillian and her ETL portfolio for her first year course, which has some echoes of this, but she has students work in teams. I'm now teaching contracts this fall. I'm having students do memos in teams. I'm not having my upper level students work in teams this year because I think I need to train my 1Ls about the expectations to work in teams before I can introduce that technique in the upper level. So if I come back in 2 or 3 years, what I'm doing in my IP classes will likely look somewhat the same, but also somewhat different. And with that, I'll stop. Thank you.